Since we've been talking about these concepts in the context of trials, let me ask you about the essential elements of our adversarial system of justice. Can you describe them?
Yes. In the United States, we tend to think that justice and truth emerge most often from adversarial presentation. So we have a judge that is a neutral referee who is not really trying to guide the presentation of evidence, but rather oversee the presentation of evidence. And we have this instinctive belief that if you give both sides certain tools, like the opportunity to confront witnesses on the other side, the opportunity to uncover information that third-party witnesses might hold or that your opposing party might hold, and the opportunity to hire an advocate, that all of these things combined with the incentives that the competing parties have to want to win will create a competition out of which will emerge the closest thing to objective absolute truth. So it's a marketplace kind of approach. Just as under the First Amendment, we believe that if we let everybody speak and assert conflicting ideas, that the best, most powerful ideas will emerge and gain hold. So too with processing conflicting evidence and stories.
So if the hypothesis is that competing litigants will fight it out, so to speak, and the truth will emerge, exactly. Is there any evidence to support or not support this hypothesis?
Well, I think there's evidence to support it in the sense that the American civil and criminal justice systems have worked pretty well if you compare them to the way the rest of the world operates. That's not to say that we don't make mistakes. Sometimes guilty people are freed later because we realized that we wrongly imprisoned them. Sometimes new evidence comes to light. Sometimes courts undo their prior rulings because they realize they were wrong. I think the criticism of the adversarial system focuses largely on two things. One is that there's a gamesmanship quality to this adversarial clash. And indeed, I used a sports metaphor. I described the judge as a referee. This stuff is too important to analogize it to sports. We really shouldn't be playing games. We should be undertaking a more serious, sober inquiry. And then related to that, just as some teams win not because anything brilliant or that their coaches are doing, but they just have more talent on their team, so too people with more resources and who can hire better lawyers or better investigators, they sometimes have an advantage in this adversarial process, even if their cause isn't as just.
Can you talk about a different system other than the adversarial one? What are the essential elements of an inquisitorial system?
On the European continent, many countries make use of an inquisitorial system wherein the judge is not a neutral referee, but rather somebody whose job it is to get to the bottom of things and ask questions that the lawyers might not be asking or reach out to generate evidence that may not already be in the case. So the inquisitorial system envisions a much more active and much less neutral role for the judicial decision maker. He's not just kind of arbitrating between the parties. He is undertaking the responsibility of making sure that all of the right things get said so that he can make a decision that unearths the truth.
What's the hypothesis underlying this system?
I think there are two hypotheses. One is that professionalized judges will be or become very good at figuring out what the truth is when they're given more power and are not passive participants reacting to the lawyers, but are actually doing more of the investigatory work. That with that work and with that training that judges have in these other countries, they will do a better job in getting to the truth. And then second, the inquisitorial system is thought to overcome the problem of unequal resources between the competing parties that might be said to plague the American system, because if the judge is going to fill in the gaps where one party's lawyer doesn't have the wherewithal or the resources to do everything, then the ultimate disposition may not be as influenced by economics.
Is there evidence to support or negate the hypothesis that you just mentioned?
I think there is. I think, there's no doubt that in America today, not everybody has access to good quality legal counsel. And I think it's hard to get around the reality that having a good lawyer is instrumental to your winning your case. I would say, in 50, 60, 70% of the cases out there, maybe the evidence is one-sided so that even if the lawyers are uneven, the right result will obtain. But in 30 or 40% of the cases, whether you win or lose might depend on the quality of your lawyering. And good lawyers are more expensive than weaker lawyers. That's the way markets work. And so I think the inquisitorial model does accomplish a little bit more equality, but at a cost of having a government official have a lot more power. When I said earlier that judges become expert in these things, in the inquisitorial model, you don't have juries the way you do in the United States, where the lay people get to weigh in and bring their common sense to bear on a dispute. And in the United States, we're very wary of giving government officials too much power.
Which type of system is most prevalent in advanced democracies today, and why?
If you look at the continental democracies, the inquisitorial system reigns. If you look at common law countries like Great Britain, the United States, Canada, Australia, India, they have a more adversarial function. So I haven't counted noses or counted countries, but I think both can learn from each other.